she would know better than I would as to the specifics of that, but I believe she was indicating she had a motion denied for failing to do that, so.
Mr. Deck, you had something that you wanted to add?
We don't feel it is just to find fault with our efforts. For one, we're not bar members. For two, we are starting off with a fundamentally defective demand letter and lawsuit regarding claims 2 and 3. If only there would have been a valid adverse possession claim, we would have had the opportunity to say, we don't like the law of adverse possession, we don't want to burden Mr. Byers. Like we did not respond to the original lawsuit. We don't want him wasting money. We don't want to waste our own time. We don't want to waste the court's time. So we elected not to respond because in the summons, it said if you don't respond, they win. We get a lawsuit. I have never gotten one before. It says if you don't respond, they win. We feel this would have been for everybody's good. But nonetheless, a defective lawsuit was submitted against us, and we are trying to figure out how to deal with that.
So let me just respond to a couple of things you said up front. The court should consider that you're not bar members, that you've not been through this before. Certainly understand that position, and frankly, it makes some sense to me. However, it's pretty clear that the court's required to treat everybody appearing before it on the same level, which means that, excuse me, that the rules apply to both sides, whether you're attorneys or not. That's pretty clear, and that's not something that I can change. Mr. Dunn?
I agree with that wholeheartedly. However, their first motion to strike was not conferral compliant, and you granted that. And you denied one of my motions to compel that wasn't conferral compliant. There's an example of giving preference to them, sustaining their motion that wasn't conferral compliant. And on another occasion, you denied something as benign as a motion to compel because it wasn't conferral compliant. The attorneys have responded with statements such as, what is being asked for is irrelevant to the defenses of any party. That was said of the rental agreement. The rental agreement is irrelevant to the defenses of any party. And so I'm expected to confer with people that up front say, what you're asking for is irrelevant. One of their, our first motion to dismiss, they did not respond in the time period allowed for. And that was not granted. Which I think it was error to not grant our motion based on their failure to respond.
Generally, motions of that nature are not granted on a default basis. But back to your motion to dismiss, which is what we need to address. Just looking for one.
at the 6/24 hearing that was prematurely scheduled for their first motion for summary judgment on Claim 1, you seemed to indicate that you were wanting to grant their motion for failure for us to respond. If you review that hearing, I think a reasonable man would conclude that you acted like you wanted to grant it, but you realized, you said in that hearing, you didn't want to do anything that would create a reversible error. You gave the impression that you were wanting to grant that.
What I said is that I wanted to go forward with the hearing just because we were all there. But because it was said early, we needed to give more time. That's my recollection. In any event, with regard to your motion to dismiss for failure to state a claim, or failure to state ultimate facts sufficient to constitute a claim, ORCB 21, 8A and G4 deal with the defense of failure to state ultimate facts sufficient to constitute a claim. And those defenses can only be raised at certain times. One, in a motion to dismiss like this, you can go ahead and put your hand down. In a pleading that's permitted or ordered under ORCP 13B, that's an answer, those types of documents. And plaintiff has raised the defense there as well. 3, by motion for a judgment on the pleadings, which is not relevant to today's proceedings. And then finally, at a trial on the merits. And again, obviously, we're not there. Just go ahead and put your hand down. I'm working through my explanation. You've requested explanation several times. I'd like to give you one. The problem that we've got with this particular motion is that ORCP 21A, which deals with motions to dismiss, it very clearly indicates that those motions must be filed before you file a pleading, such as an answer. You've filed an answer, so the motion is not timely any longer. Additionally, and I think this is also important to keep in mind, with the exception of when such a request is made at a trial on the merits, the court can only consider the pleadings, that is the complaint, and the allegations that are made in them. The court must consider all well-pled allegations of the complaint as true. Whatever the facts might be, at that time the court has to consider them true. And give the plaintiff the benefit of all favorable inferences that can be drawn from the facts that are alleged. I can't consider any additional evidence from outside the pleadings. If a complaint states facts sufficient to constitute a claim for relief, if it contains allegations which permit the introduction of evidence which will satisfy the elements of the claim. Your motion at this time depends on and cites a considerable amount of evidence, and I'll call it evidence. It's not presented in a declaration or affidavit, it's just outlined statements in the motion. But those are all outside the complaint, and so I can't consider them. Effectively, the defendants are asking the court to make a judgment regarding the evidence of the case that's presented in their motion, not on the allegations that are made in the complaint. It's a procedural distinction, but it's in the rules, and I'm required to follow it. The court can make such an evidentiary determination at a motion for summary judgment if the evidence is such that there's no genuine issue of material fact. If there is, at a summary judgment, the court obviously needs to deny that summary judgment, and we go forward to trial where the finder of fact needs to address what the facts are, whether that's a jury or the judge. Again, that step to review the evidence is appropriately made in a motion for summary judgment based on declarations or affidavits that are required to be filed by the rule in response to the motion or supplementing the motion, or again, at a trial. A similar motion to this was made and denied back in February for the same reasons. It was made post the filing of the answer, and I couldn't address it. You've mentioned your motion to strike that you had filed. I don't recall that I mentioned a conferral being I do recall that motion. That was the motion to strike the estate's pleadings. The estate was a defaulted party and was out of the suit. There's no need to confer with the defaulted party. That is clearly a rule. So given those reasons, I'm going to deny the motion to dismiss because, again, it's not timely. And also, even if it was timely, it would depend on facts outside the four corners of the complaint, which I can't consider on a motion to dismiss. Mr. Dunn.
Well, as of yesterday, they're attempting to amend their pleadings.
They are.
And so that,
and
I don't know.
procedurally, that might put us in a different place at some point down the line. Today, this is what we're doing.
Are you saying at trial I can present this very same motion?
I don't know that you would raise it as a motion. You have it raised in your answer as an affirmative defense, which means you can submit evidence which would establish the issues that you've raised there with regard to possession and submit that to the jury if appropriate. If there was no evidence to support their position that came in during trial, you could request a directed verdict, which would be a similar motion. It wouldn't be the same motion. So then let's move on to, I'm going to come back to that one actually. Let's move on to the motion to strike a sham pleading, which was filed November 17th. Mr. Dyke, with regard to that motion to strike a sham pleading, possession, damages, pleading claim 2 and 3, as well as striking 2 and 3.
Yes, Your Honor, we think it's patent and self-evident that the pleadings are sham and without merit. At one point, the plaintiff says, since 2000, parcel D was not in the actual possession of any person other than myself and my family. The plaintiff's counsel here was willing to agree to stipulation contrary to that. So what is being coming forth now is totally contrary to the history of the pleadings and papers maintained by the plaintiff for a year and a half.
Anything else?
Exhibit 1, what do we have here? Exhibit 1 is the plaintiff's counsel's attorney, his letter to Stewart Title. In that letter, he includes a demand letter. In that demand letter are what we claim are sham pleadings. In the demand letter sent to Stewart Title on March 26th, it says that the owner of the property, Mr. Byers, is entitled to exclusive possession and quiet enjoyment of the property. This was forwarded to Stewart Title with the exhortation for them to sue us. And they passed it on to a huge law firm who accepted it, apparently without verification. So the defective demand letter, which was cut and pasted into the lawsuit, has made this extremely complicated and problematic, and we believe there's mounting evidence to show that those pleadings are sham and frivolous. Especially in the light of the October 31st filings, whereby Mr. Byers, out of his imagination, thinks that $50 a day is a fair compensation for his damages, even though he lived 100 miles away from this property. I might have other exhibits there. The exhibit of the plaintiff's counsel's letter to the title company, it shows that a delay was made, and there are emails that have been discovered showing that there was a collusion between the plaintiff's attorney and Wasco Title. At one point they said Mr. Dyke might contact Stewart Title, and somebody was getting nervous about that. Unfortunately, when we went to Stewart Title, they didn't say, here's a claim number, go contact Stewart Title. A title claim can be made online, but that wasn't done. And so there was a delay. So now we understand why when we went to Wasco Title, they said, you're not the insured. We don't owe you anything. They should have said, a title claim has been filed. And so we see the trail. We see how the trail of how a defective demand letter was adopted by a law firm in a lawsuit against us. They've even admitted, it has been admitted through a request for admissions, that the plaintiff's former attorney had no knowledge of whether the property is being rented. And furthermore, in one case, the plaintiff's former attorney said it's irrelevant. Well, of course, that's contrary to the papers filed by this attorney on October 31st. Contrary to all that trash that has resulted from a defective demand letter. You suffered it, they suffered it, we agonized over it, and here we are today. And we believe the case for sham pleadings regarding claims 2 and 3 is building. I might have another exhibit. Wasco Title is interested in the least expensive local solution possible. I mean, how does that regard Mr. Buyer's interests? If a delay in an evasion of making a proper title claim is not made. Here's an email from this attorney to Chris, title agent. Spoke with Dan about holding off until a lawsuit is filed to tender defense to Stewart.
Mr. Dyke, I appreciate that there's a lot to this. But how does any of that relate to whether or not the motion to strike is appropriate because it's a sham pleading?
I believe that the ORCP allows for the striking of pleadings that are not valid.
Mr. TISSOT?
So I'm admittedly guessing at what Mr. Duck is speaking about.
Objection.
What's the objection?
I don't like him influencing the record or others by his guessing.
Go ahead.
But what I believe he is referring to is that there was an allegation in claim number 1 that Mr. Byers was in possession during the relevant time period for adverse possession. And so, and that is true, and that adverse possession claim has now been resolved.
Objection.
So that is dealt with. Then when it comes to possession for the purposes of trespass, different kind of possession, we again have stated that actual possession was in the tenant's name, and then that the claims were assigned to Mr. Byers.
Objection.
So here's the issue on the motion to strike. Again, under ORCP 21 sub E this time for motion to strike. It reads as follows: upon a motion made by a party before responding to a pleading, or if no responsive pleading is permitted, upon a motion made within 10 days after service of the pleading, the court may order stricken any sham, frivolous, irrelevant pleading, defense, etc., and so on. We're obviously well past responding to the complaint or the amended complaint, because you have, in fact, filed an answer. Yes, Mr.
I believe that the plaintiff's motion to strike would not have been timely either.
That the plaintiff, the pleadings of the estate?
Their motion to strike, I believe it would be found to be untimely as well.
And I don't recall the timeline on that, but the court's certainly free to strike filings made by a party that's not a party, an entity that's no longer a party to the case. So because this wasn't timely, I'm going to deny that as well, which moves us to the motion for judicial notice of ORS 20808, and I'm just going to take that one. Judicial notice is a rule of evidence, Rule 201, which also can be cited as ORS 40.060 to 40.085. That governs judicial notice of adjudicative facts. ORS 40.090 or Rule 202 governs judicial notice of law. I'm not entirely clear if defendants requesting that I take judicial notice of facts related to ORS 20.080's importance to this case, which may be dramatically less given the recent disclosure of the assignment claim, but that remains to be seen, or simply take judicial notice of the statute itself. If it's the facts that the defendants want me to take judicial notice of, that would only be possible if the facts are not subject to a reasonable dispute because they are generally known to the territorial jurisdiction of the trial court or are capable of accurate and ready determination by resort to a source whose accuracy cannot be reasonably questioned. That's clearly not the case for the facts outlined in the defendant's motion. Everybody's disputing those facts. Or Mr. Dyke's defective declaration. The declaration wasn't signed and doesn't contain the language that's required by ORCP 1E for a declaration. That is the language that it's subject to perjury, etc., which I won't try and quote from the top of my head. If it's merely the existence of the statute that defendant wants me to take judicial notice of, the law of the state of Oregon is already judicially noticed by Rule 202 without the need for a motion or a request to take judicial notice. So if the request is that I take judicial notice of the facts that are outlined in that motion, I would deny the motion. If it's that I take judicial notice of the statute, that's already done and isn't necessary.
According to Powers 345 OR AT 439, it explains the intent of ORS 20.080, which is, it's not just a statute.
Hang on, Mr. Dyke. Are you asking that I take judicial notice of that case?
Okay.
I mean, is that what you're trying to do?
I would like you to take notice of the intent of ORS 20.0.
And it sounds like you're quoting from a case I know well, and Rule 202 of the Evidence Code gives the court judicial notice of all Oregon cases. So if and when we get to the point of arguing about whether or not that statute has any impact in this case, you're certainly free to cite it. It would be considered part of the law that I can consider. We don't need a motion at this point to take judicial notice of Oregon statutes, Oregon case law, administrative rules, etc. So then that moves us to defendant's motion for judicial explanation, and while I certainly understand, and maybe I don't understand, but I appreciate your frustration with the process, I believe I've previously explained each of my rulings in the case. I certainly haven't turned a deaf ear to what you've referred to in your motion as the necessity of possession. I would refer you specifically to my rulings on the motion to dismiss from February 11th of this year, as well as the ruling on that motion today. While those motions were denied, they weren't based on any sort of evidentiary finding that possession is not necessary for purposes in this case, or that possession isn't an issue in this case. They're based on the timeliness of the motion and statutory limits that are imposed on what I can consider when ruling on a motion to dismiss. So I guess for purposes of the record, I'll deny that motion, but I certainly intend to continue to give you explanations to the extent that I can of my rulings. I think all parties are entitled to that, and it would be my intention to provide them. I don't think a motion is necessary to get that. Then you filed a motion for a jury trial. Mr. Tissot, was there any reason, basis, otherwise that we would prevent this from being a jury trial? Assuming we get past a motion for summary judgment?
No.
I don't see one either. Mr. Knight, you're entitled to a jury trial in this sense, without the need for a motion. Unless both parties waive that right, or it gets resolved in a motion for summary judgment in favor of either party. If this goes to trial, it's a jury trial unless I hear otherwise from both parties. Then we've got another motion for judicial notice of a statute. Again, Mr. Knight, I don't need to take judicial notice of the statute. I already have judicial notice of the statutes under the evidence rules. Let's see, that then gets me to, I'm going to skip that one. I'm going to go to the motion for bench supplementation, which I think is a request to have an additional judge assist on the case. Mr. Beck, I'm not aware of any authority for that. And again, it appears your concern is primarily how I addressed the motions to dismiss and how the possession issue relates to them. I don't think it's appropriate to add another judge. I don't think there's a process to do that at this point. If ultimately where we come out you've got an issue with, you're certainly welcome to appeal the case. Hopefully that won't be necessary. We'll end up with a decision that is correct on both the law and the facts. It may take longer than you believe is necessary to get there, but I'm constrained by the rules of procedure that we are required to follow.
Can you forecast how long it might take to simply address the matter of possession?
I would love to tell you that I can, but I would be lying.
Should we budget years, months?
I would hope it's in the neighborhood of months as opposed to years. A significant issue addressing that is the ongoing discovery disputes. Some of that we'll touch on here in a moment because now we've got this other motion to deal with, this potential supplementation of the complaint, which I think we can get into this to some degree, raises some new issues, or maybe not new issues, but puts them in the pleadings as new issues, which may create some additional avenues for discovery, some of which I think you've already raised in requests that you filed, which may extend the time before we can get to a summary judgment, which we're going to address here in a moment. Summary judgment would be an opportunity to address possession on an evidentiary basis, keeping in mind that if either side presents sufficient evidence that there is some question, a genuine issue of material fact, fancy lawyer language of saying there's some real question, the summary judgment would be denied and we'd go forward towards trial where, at this point, a jury of 12 people would figure out what the facts are and go forward. They would do that based on the laws they're instructed, and we have some kind of a decision. So, let me see. I skipped a couple motions as I was cruising through here. One was your motion to dismiss or continue the plaintiff's motion for summary judgment. Mr. Tissot raised a couple of procedural issues on that one. Let me